So watu warudi pale kwanza. Watu warudi pale. No. Please, please. Meet on the streets. The same time. Meet on the streets. 10. What? Yes, Papa.
We shall overcome. We shall overcome. We shall overcome someday. Deep in my heart, I do believe we shall overcome someday. We shall live in peace. We shall live in peace. We shall live in peace. We shall live in peace someday.
Take some 5 minutes to get some pictures. So I think we can.
So now they are saying simple. The other case is like which case the one of
Bali mukufukira abantu na Kenya. Ani ajoge. But you realize
That is not the negotiable. Thank you.
Utora bantu ko nje ni jemba ndi pasitani
I have permission and then we've got permission with the council. My Lord Mayor.
Okwagula eddaganya okutuula.
Please, Chairman and court members, attorneys for the state.
Silas Ogul, Tugume KB Moses, Irumba Robert Musime, Akakimpa Godfrey, Samuel Muyizi Mulindwa, Kijambu Gordon Mukisa, Alinitwe Peter. Now we have issues here with the retired Major Ronald Iduri, who is part of the legal team. But as you will be notified, Mr. Chairman and honorable members, we received some disturbing news this morning that he was abducted in the wee hours, and one of our colleagues will substantiate on that because it's a matter of concern to our legal team. We also have Edwin Kafura, Bowe Aipan, Upman, regarding her practicing certificate to be able to have audience before this honorable tribunal. It's actually on that account that this honorable tribunal deemed it necessary to have the proceedings deferred to allow us that time to finalize the process. Where we stand today, the status quo has not changed, Mr. Chairman. There are matters which are still before the Law Council. We have gotten a communication from the Law Council which we would like to share with you, Mr. Chairman, and the response has been made by the senior counsel here. We are waiting their pronouncement of the same or further processes, because we feel this is a matter of great concern to not only the accused persons, but also this honorable tribunal choose lawyers they deem competent enough to deal with their matter. And under Article 28, this honorable tribunal is enjoined to facilitate the accused persons with all what they require to be able to prepare their defense effectively. And one of the tools they require to effectively prepare their defense is to have a formidable and competent team duly constituted. So in a nutshell, Mr. Chairman, we are still in the process of having our legal team fully constituted, because right now our legal counsel has not been cleared by the Law Council, and there are issues that have been raised by the Law Council, one of which being, Mr. Chairman, the need to prove that there is value addition she's going to make in this matter, and that will prove that indeed her presence in this matter is critical, is important for effective dispensation of this ruling of the Law Council. And finally, Mr. Chairman, the question Mr. Chairman, I wasn't advised that the court had read newspapers. So it's the reason I was laying the foundation for this case. I thought the court acts on evidence, and I wanted to submit this to court for record purposes. And with all due respect, I don't know which newspaper I can.
That being the case, we have talked before court stated, and even we agreed that she has to be given a seat, but she will not participate in the proceedings. So if you are the one leading the team, proceed about the case.
Precisely the point I was making, I have not been instructed to lead the team. The instructions to lead the team remain with the Honorable Martha Karua. And that is the point I very much wanted to put on record to guide the proceedings. And with your permission, allow me to submit this document together with the response given by the Honorable Martha Karua. These documents for record purposes. The response is here. Mr. Chairman, if you may, for record purposes. So the long and short of it, Mr. Chairman, as I sum up my submissions, the accused persons are still in the process of constituting their legal team, and this is what we are still dealing with. And it's an inalienable right, a non-derogable right under our Constitution that they must be accorded the right to a fair hearing. They must be accorded the facilities to be able to adequately and effectively prepare their defense. So we are still at that stage, Mr. Chairman and honorable members.
Thank you, Mr. Chairman and members of the Honorable Tribunal, the military tribunal. On the issue of where
Council Chisa, if you read the UPDF Act, we don't have the word tribunal in the UPDF Act.
the English meaning of tribunal is court.
You read the Act, what does it, what is court under?
Judge, advocate, you are not supposed to exchange with me. You are not a member of the court. You should advise it and they tell me. You are not a member of the court. You are not a member of the court. You advise court and court rules.
Listen, my advice to this court is final.
No. You are not a member of court. He is not a member of court.
Can you first read section 169?
Read it.
UPDF Act.
Read it.
And section 2.
Read it. Read it.
You read that.
No, read it. No, you can't read it. You are not court.
Can you listen?
We have rules of this court. It is not going to be like a political rally. Read section 169 and section 212. We don't know about that.
I'm sorry about the interruption.
You wait till they read for you the law, because you may end up in the wrong hands of the law today.
Even you may end up there.
Just listen and they read for you.
Order, please.
But he's misleading the people.
Order, please. First listen to what the judge advocate is saying, and then we proceed.
That vigilance will work for the army.
This is the court. I don't want to hear the word tribunal because it is not under the UPDF Act.
That is guidance that only comes from the court, members of the court, not from a judge advocate.
This is Chisa, section 212, witnesses and advocates at military courts. And I will refer you to subsection 9. Any conduct of an advocate before a unit disciplinary committee or court martial that would be liable to censure or be contempt of court if it took place before a civil court is likewise liable to ensure or is contempt of court in the case of a unit disciplinary committee or court martial, and the provisions governing the procedure of unit disciplinary committees or court martial are binding upon an advocate appearing before unit disciplinary committee or court martial, and willful disobedience of provisions shall, if perceived be deemed to be in contempt of court, punishable in accordance with section 169. So, what section 169? Section 9.
For serving officers.
Section 169, offences in respect of military courts. I take you to 1. Any person who, being an advocate, conducts himself or herself in a manner described in section 212, subsection 9, will have committed an offense and is liable to conviction to imprisonment for a term not exceeding 5 years. So, as you address this court, I'm just giving you another warning that you must read the law. We are in court, we are not on a rally.
Chair, with due respect to the provisions read, to the provisions read, so whatsoever he has read, he cannot in any way determine what we advocates for the defense say. We are not under his command, and nor can he determine what court decides.
No, you can say it, but be orderly. You are not going to
what council should say on our behalf, and we do not have that right.
So, can I read to you the rules? I'm the judge advocate of this court, and I'm the one responsible for making sure that everything moves on procedurally here. You cannot be a judge in your own court. That's why we're in court here.
There is a judge in this court. They are the investigator, arrester, prosecutor, judge. What are you talking about?
Where do you get those facts?
Do you want to surprise the facts of abduction? Do you?
So,
Do you want surprise?
Chila, you can go ahead and submit. I've given you the...
So, we are talking... can I have the mic? Before the mic is not working. What is working here? Yes, thank you for the guidance that the defense lawyers are working. So, Honorable Chairman and members of this military tribunal, we have 3 issues which my senior land counsel alluded to, but I will start with the abduction because abduction is a derogation of Article 44, paragraph C of the 1995 Ugandan Constitution, it is a sacrosanct right that should be not so. I'm not talking about the abduction of the accused persons from Kenya to Uganda and they are in concomitant incommunicado detention, which has resulted into this proceeding. What I'm talking about is that a member of our defense team, retired Major Iduri Ronald, has been abducted this morning towards 5 a.m. and he's not able to represent Dr. Chiza Besije and Haji Rutale Obied Kamlegia. And that means we are unable, our hands are tied. Our team is incomplete. Even if it was complete, there's a lot to say about that, but we want to note that we feel that this is a form of intimidation on the legal team. The last time I appeared here in the morning, I found soldiers on my office. I ignored them because if they had touched me, I would have beaten them. But there are some members of this team who don't want an association with soldiers around their offices, around their homes. Major Iduri Ronald didn't open the door for them. They broke the door and he left the phone on, and his siblings could hear the wreckage reminiscent of the abduction of Kakwenza, how it unfolded. So we hope this Honorable Military Tribunal can rein into the conduct of the military so that we don't have a repetition of this unfortunate development whereby a member of the Rotary and the Besije defense team is arrested for precisely doing their work. If Iduri had not been arrested, he would be here with us and would be in a much better shape, including even on the knowledge of the rules. Because Iduri, I started practicing with him for this honorable military tribunal in 2014. I have been around. We started in Kasese, one in Bundubujo, we were in Jinja, and I'm an old hand at this. We have 3 visiting jurists and seated here on the front because she's the team leader. She will not speak, she will not submit when eventually we get to trial, but her right as senior counsel to sit on the bar is untouchable. Then the seating arrangement, your honorable chairman and members of this military tribunal, we are unable to proceed with any further when our colleagues are standing, because there is no way we can proceed in this fashion. We pray that this honorable court sorts the seating arrangement of our colleagues before, as a defense, we can proceed any further. Thank you.
I rise to express our displeasure as regards the manner we have been treated at the entrance. When we enter here in these premises, we are supposed to be officers of court, and we should be treated as such. However, after here, we go back when we don't need any further gym, any further work. After here, we are so tired. As we talk now, we are extremely tired because of the mistreatment. The soldiers take us through. This should be changed. Indeed, there is nothing which resembles a court, depending on the conduct of the soldiers out there. Mr. Chairman, it is my humble request that this honorable tribunal benchmarks with the other courts, allow us the permission to treat it as a court. Indeed, the way we are treated, we are right to say that we and our clients are being persecuted. Our clients are not being prosecuted, but rather persecuted. Your soldiers out there are determining who to lead us, where to sit, who speak what. Indeed, we are not grateful with that kind of treatment. This is not what is done in courts of judicature. Something must be done, Mr. Chairman. As you lead by example, that example must be seen. That is the motto. By example, we lead. That is the UPDF motto. But sincerely, there is nothing to emulate from the conduct of soldiers out there, treating us as if we are criminals, as if we are convicts. We are not. We are good people, and we love you guys. We love you, soldiers. Don't treat us like that. Tukoye.
Okay.
Thank you.
Mr. Chairman, I request we respect the rules regulating court processes. When an advocate is instructed, they have a right of audience. Each of us here were instructed to represent the accused persons. So even if all the 40 were to speak, they breach no law. So I kindly and humbly request the judge advocate to hold the fire.
No, the issue is we want to know who filed the practitioner certificate with the registrar.
But the thing is, we have put the names on record. We want those who are supposed to have audience.
We want the practitioner certificate of whoever advocate appearing here, and it is done in the civil court.
Order, please. Honorable Alukwago, I wanted to talk about that in my small communication here. When you talked of sitting arrangement, from what the registrar has, he told us 10 people who have fulfilled the requirement. And that's why the arrangement is like that. We expected 10 people, and those who have not fulfilled to be in the seats highly there. Why? First of all, Councillor Babu, you were self, you did what you were supposed to do. Others did not do it. Now what is that? Why is it like that? Why is it like that? So Judge Advocate was asking the registrar to update the code. How many people or who are they who fulfill the requirements? Can you please tell us that?
In prayer, in arrest of that ruling, I checked, Uganda was being governed by a constitution. In section 2 of that article 2 of that constitution, it was binding on all authorities, all persons, including the judge advocate, including this court, every member, and it is to the effect of that constitution that the right to a fair hearing is sacrosanct. That right to a fair hearing includes the accused persons, in this case our clients, choosing their lawyers, the number of the lawyers, and even now as we speak, they can add on the number of lawyers. It is not the province of any court in any land, not even the Supreme Court can tell the accused.
Council Chiza, we are not limiting anybody. We are just talking about the procedure.
I am trying to say that that procedure, to the extent that it tries to stop Besige from hiring a new lawyer right now and submitting it before you, is null and void. And the solution to such a null and void notices is in several provisions of the Constitution. There is 274, and another is 1262. The 1262 says that substantive justice, and there is no justice more substantive than the right of the lawyer, the right of an accused to choose their lawyer. And that right, when I say this sacrosanct, I mean it cannot be modified by anyone, not even the President of the Republic of Uganda can modify the right to a fair hearing. Right now, even at thinking, we can substitute council. As we speak, we can get a new council. So the idea of 48-hour notice, we reject it as null and void. Family, we are not. The fact that me and Rukwago brought a notice does not mean that we are amending the constitution of the Uganda. That was a bonus, and since the accused have since added on the lawyers, and no one can tell the accused which lawyers to appear today. That's why we are unable to proceed without our colleagues.
As you know, under the constitution, the formation of the UPDF, and Article 208, I will go to 2, that the Uganda People's Defense Forces shall be non-partisan, national in character, patriotic, professional, disciplined, productive, and subordinate to the civilian authority as established under this constitution. We form part of the civilians, Mr. Chairman of the Tribunal. 2, clause 3 is that the members of the Uganda People's Defense Forces shall be citizens of Uganda and of good character. Mr. Chairman and your tribunal, the character depicted by the members at your entrance there is not of good character. Secondly, I can see you have your name tags on your uniforms. I think those issues, I don't think that's why we are here. First of all, we are sorting out the issue of advocates.
Yes,
Honorable Kwago said people are standing. You are going taking us astray.
Advocate Judge, let me address my issue, then you can respond.
No, because that issue, because
this is a very sensitive issue.
Councillor has talked about it.
With all due respect, my issue is a different issue. It's about identification of the people that you put at the center as we enter. You can't know who manhandled me, who battered me, and you should act as good examples to the rest of the people. You are people with superior powers to guide the professionalism and conduct of the people. Why can't that be so that we know who is addressing us and at what time by putting on their name tags in there? Thank you.
Council, you have heard about the conduct, and I have heard from your side. I will interact with those people at the gate who are manning the security. I believe that one will be solved.
Registrar still, you have said you have your PC. I don't think anybody is going to put on a suit and a tie and come here and serve a lawyer. So we are going to prove that by a PC. If you don't have a PC filed with the registrar, we shall not recognize you in this court.
Mr. Chairman, we take exception. No areas. Establish our PCs. Here it is.
Council, we have not asked you. There are those who have not submitted.
Let's enter the issue. So there is what we call a digital system and the court. Even if you want to know the lawyers who are entitled to practice, you can Google them on the Uganda Law Society website. They are public, are available. That should not be a problem. It's not a problem of the accused. I think whoever is trying to create that problem should deal with it, but the accused has chosen competent lawyers, and whoever is in doubt of their qualifications should Google them.
And for any doubt, they can proceed to the law council for those holding out.
He who alleges must prove. I'm alleging that. You are saying you are not advocate, you have to prove us without a PC. And it is not negotiable by the way.
Should raise the chief registrar. It's the only person who gives the chief registrar by the letter, and the letter, the list is submitted saying this one and this one are not enrolled at all. That would have solved it. It is not him that gets to an attack because he does not hold the wrong angle. He does not.
I don't hold it, but I am moving other regulations governing the court.
You do not certifying authority to certify whether somebody has this is ready or not.
Anyway, the matter is simple, and my guidance is final. I'm telling you, you have to file your pieces with the registrar. That's it.
Mr. Chairman, the should be pronounced that whether the interpretation by the judge advocate is final and is binding on all this court and on all of us, whether it is ill-advised or not, whether it is misconceived or not, we need to get a position on that. Because otherwise that would be violation of the principles of fair hearing. Because fair hearing will be hard by the and the decision made.
Chairman is intimidated.
For avoidance of doubt, we do not need to hear from the chairman to know that the judge advocate is misleading court. The primary character, the defining feature of any tribunal, including quasi-judicial tribunals, is judicial independence. If a tribunal is telling us that it is not independent, that whatever the judge advocate says, they will swallow it, hook, line, and sinker, then we have no business here.
The word tribunal, we don't have a tribunal here.
I don't know how many times I will tell you that this is a military tribunal. There is a dictionary, you can look it up. The meaning of tribunal. I'm getting tired.
Council Chiefs, I think, Council, we are not doing this honestly. Because I don't see what harm does it make you to follow the procedure and bring your PC and instructions to registrar so that we know people we are dealing with. What's wrong with that? Why do we waste time on this?
Because, Honorable Chairman, we have put it in black and white. We have put ink to paper. We have.
And you are asking court to find out, to go on Google and find out whether you are practicing or doing what.
In the cases, just a minute. In the cases where what you Chairman, in the cases where the court doesn't want to Google, they formally write to the chief registrar of the courts of judicature, and the chief registrar writes back indicating that this person is not enrolled or licensed for this year, or he is. That is how the procedure for courts that was their sort to do.
You talked of Major who was arrested or
Retired Major Iduri was abducted a few minutes towards 5 a.m. this morning by members of the Joint Security Team, including the military, to which this military tribunal belongs. And that's why we are using the good offices.
It's good you know who arrested him. I think you can either approach them or pressurize them to produce him to court so that you can start from there. Otherwise,
our complaint, Your Honor, is that Mr. Chairman, is that he is a member of the defense team. The reason this team is incomplete is because he has been abducted by members of UPDF.
And that's what I'm saying. It's good you know who arrested them. Members of UPDF, I think there are many departments. I don't know who arrested him. Is it the court or is it the... Who arrested?
It's not the court.
Who arrested?
They are like the ones we met there without tags. The guys we met at the gate, they are also like them. They are without tags. Some of them are Yes, it's a nasty situation. The owner, when abduction is terrible.
Since you know them, that's what you can handle.
We are military strangers. We just know they are military men, but they are not identifiable.
If he's brought here, then we will listen. And Councillor Kwago, you again talked about it. Led by the Law Council, according to the document you have presented here. So before she's not cleared, I don't know what you have. Can you read the team or not?
Chair and honorable members, unequivocal instructions we got from council here, the law council, if I may read page 3 of page 6, paragraph G. The law council is composed of members who have full-time jobs in other government agencies and as private practitioners. They require adequate notice in order to meet and consider applications. We believe they have not had ample time to canvass all the issues they needed to deal with, given that statement. So it would be premature for any decision to be taken at this stage before we exhaust all these processes. We believe the Law Council, in making that statement, they wanted to get more time to deal with this. Never mind that they indicated some issues which we find objectionable, like the political connotations and other matters, which we can put squarely to them. And as I indicated earlier, Chairman, issues they were raising have been adequately responded to. They are going to reconvene and take an appropriate decision. So this is, we are saying, on the understanding that the accused persons have got a right to constitute a legal team to defend them. The right to legal representation is sacrosanct, is non-derogable. That is the whole point. And they want to have an effective team. And these are not the usual process the senior council coming from. And that is the reason we find strange the reason advanced by the Law Council that they don't expect any special skill the senior council is going to bring onto this matter. Maybe they were oblivious of these facts, but now that there is a rebuttal.
So you, as if you wanted to say anything?
Somebody wants to say something. Somebody wants to say something.
How my point is one of the comments that was raised was that the lawyers are speeches. I'm not advocating, but from my observation, when you look at our colleagues, how they are conducting themselves before this court, must change. Then my prayer, this court is that which country is what court party. It's a court matter. The charge sheet is from the other. I think I is called by Mr. Matters before court is discussed. And I've seen him several times including Aaron Chisa, who is referring to this court as criminals. My understanding of
can I substantiate myself?
No,
it is you sit down. When I raise, if you are a lawyer who went to law school, sit down, don't waste our time. If I stand up, you sit, it is automatic. It's automatic. No, that is okay. Then you did the lunch before me, I learned before you. No.
When they were talking,
you see, when a lawyer stands up, you sit automatically. You didn't learn that in school. You didn't learn that.
Council Chiefs, why you don't be patient? Submit and then you are given
You don't just mention every cheese of God. No. Stay it up. Stay it up. Yes, I'm of wisdom and knowledge. Yes. Yes, of course, yes, I'm happy you recognize it.
Can you listen?
And I do believe that Council Chiefs, you know where you are supposed to take your grievances. Why do you take them to the public? No, I'm listening. Why do you take these complaints to the public? Why do if you are not agreeing with what you know you are supposed to go to another court? The other time you appeared here, you first made press-ups outside the court. What when you talk to the 5 years we're talking about, when you thought that you must first make press-ups before you go to court, and when you're standing with the exercise, you are supposed to take a shower. You stand there 5 years. I want the act according to the day. You come to the constitution, you say it was for a committee. So, he is trying to avoid those actions that you are doing. Come when you are proposing, and when you are prepared to proceed with the matter. So, I pray that these people be restrained from talking about the matter which is before God. You can see some way. I can really recognize some revered lawyers. I've not had him talking with him, and I think he's waiting for evidence. But some people come here just to make a show. Ernest Karibara, you see him. He's a respected lawyer. I've not seen him making any noise. No, he's waiting for evidence, not a show. So I pray that these lawyers be restrained from discussing matters, especially touching evidence. So if you go with the judge, so what will the public do? They are going to advise you to go to the personal and that will be the direction. So in regard to my question, I wanted to clear this issue, saying this person was abducted. No, we are not having the person before here who was abducted. There is East African protocol.
We are not yet at that point. So the out issues by council. Please,
no disclosure of that document.
There is no disclosure of what you're stating.
No. It is a process.
Then stop wasting our time.
Not waste our time by proceeding.
Don't waste our time. Don't waste our time. Either you share it or you sit down. No, we need a copy. We need a copy of that notice.
We are objecting to your conduct.
Look at how you are conducting the charge. The charge is different. You know where to take it. It's not the public that is going to find this.
What of the audios?
Ewa.
Yes.
Yes.
Ewa tuchukua.
Yes.
It's a valid question.
Chairman, I pray that issue.
Nade manyizirisa nga mu kitwale. Genda n'ekiro sigenda fuleminga ekiriwo kyotwala kuba tewaliwo kiri gundi. Ono ayogera olaayogera just genda kubeerawo.
We have a response to the application. Does not in any way be grounded on matters of law. I believe we attempted to submit on issues of sub-judice. I hope we have come adequately prepared to make his own submission on that particular matter. Because there is a wealth of authorities on the rule of sub-judice, and he has not cited any of the authorities or principle or anything. But if I may help him on this, the rule of sub-judice, Mr. Chairman, is not absolute. It's structured in such a way that one shall not discuss a matter which is before court in a manner that is likely to prejudice the outcome of the case. It is qualified in a manner that is likely to prejudice the outcome of the case. That is one. Two, discuss a matter which is before a court of competent record, a court of judicature. If matters are before a disciplinary committee, for example, they are before a tribunal, they are before an LC court. I'm not suggesting this is one. I request you take it in good faith, Mr. Chairman. I'm just giving an example. So the rule of sub-judice is not of universal application. It's about courts of judicature. So if it's a matter which is before the General Court Martial, which is not a court of judicature, which is not a court of competent record, you ought to have come prepared with the authorities to stretch the application of that rule to the proceedings here. And I make those submissions well advised that they are good authorities to that effect. We are not expecting him to raise it. But that said, Mr. Chairman, again, the rule does not bar anyone, not even advocates, not even members of the public, to discuss decided cases. He talked about our continued pronouncement of the trial of civilians before the General Court Martial. There is a court decision chain. So, Mr. Chairman, I want to conclude by asking that those issues he's raising shouldn't be entertained. Here, what needs to be done at this particular time is for us to have the team of lawyers, because we are still considering preliminary matters. Those are the preliminary matters we raised. We want to constitute our team fully and be able to proceed with the matter as and when we are ready to proceed. So I beg, Mr. Chairman, that the application he has raised, and to me in particular, you see, he mentioned my name, and I wish he cited anywhere where I featured and offended the rules, but that is besides the point. But if I may also ask him, as I conclude, Mr. Chairman, is he asking for orders to restrain debate worldwide, because this matter is not only restricted to the confines of Uganda. It is on CNN, on Al Jazeera, on AV, on KKNT, it is everywhere being discussed. So, of what I don't know, the confines of the orders, whether this General Court Martial has got orders to order the world never to talk about Dr. Besigye case until a decision is rendered. So that would be really outrageous with all due respect. It would be absurd and it shouldn't be entertained. I beg to move, Mr. Chairman.
A pastor is a function of religious freedom. It is outlined in the Constitution. It's a human right inalienable. Going to witchcraft, if I wanted witchcraft, I would have gone to Raphael. I didn't. Where to take grievances, yes, I know. Press-ups, I want to be healthy. I don't want to look like some people. About the profession, yes, I'm an honorary member of the profession, and on civil society, the Uganda Law Society has recognized me. About rhetoric, now we can't get into poetry. We are here to discuss law. So I still leave the rhetoric to him. The word promulgated means bringing into effect. Laws are promulgated. I don't know what I am not responsible for the inability of the prosecutor to understand what I'm saying. I am not responsible. There are some things that on prayers of restraint, that one are not dignified to comment. On prejudice, he needs to address himself to Article 29 of the Constitution before he submits on prejudice. He hasn't. Has he? No. The charge sheet, yes, it is a public document because there is an assumption that a quasi-tribunal is a public body whose documents can be shared. We shall continue sharing charge sheets in WhatsApp, with media, on my Twitter. It's even there. You will not remove it. And we shall debate it. Abduction, it is a fact. You can't try for it. You abducted. The people here, these two people are a product of extraterritorial abduction and extraordinary rendition. Those are the English terms. If any breakdown is needed, I am ready. These are victims of abduction, of heinous kidnapping. They are here because some soldiers committed crime in Kenya on 16th of November. Those soldiers have not been brought to book, and tomorrow I'm going to write to the CDF to give me names of the criminals who brought Besigye and Luzira here in the breach of Kenyan law, of Ugandan law, and East African Community law, and the African Charter on Human and People's Rights, and the Universal Declaration of Human Rights, and the International Covenant on Civil and Political Rights, on the Convention Against Torture, and other legal instruments. Raphael will not stop that. That's a discussion between me and the CDF. It's above him. Kidnap are crimes under the laws of Uganda. No member no citizen of Uganda should be here to drum support for kidnap and abduction. The duty of anyone who has witnessed abduction in community detention is to report to police or appropriate authorities. This should be the last time that someone is raising with this court in this military tribunal to support abduction. We should all condemn it. The memoranda he was trying to read is a secret. There is no law which is separate. Laws must be gazetted. Whatever you're reading is null and void. Indeed, these are older men. The last time I checked, Besigye was around 68. Rotary was crossing nearby. So if you are going to hold old men standing for these hours as lawyers urge the law, or what looks like law, it's going to be unfortunate. I mean, what looks like in the case of Raphael. It is also unjust that our colleagues we have raised it, we are unable to proceed further because we cannot proceed when our colleagues have nowhere to sit. It vindicates those who say that this is a kangaroo court. Kangaroo means unfair in case someone doesn't understand it, and I know who will not understand it.
Mr. Chairman, 2 sentences, Mr. Chairman. I will have ended my submission. Mr. Chairman, the prosecutor is inviting you to restrain our freedom of speech without any evidence, without any justification, without any basis. He is blackmailing us, Mr. Chairman. I believe you have heard from his statements, attacking even our conduct from outside this tribunal, Mr. Chairman. For instance, when he cited the press-ups which were made by my land friend. Mr. Chairman, I invite this tribunal to treat his submissions as mere statements from the bar. The same should be disregarded as being without procedural or evidential value. Mr. Chairman, overrule the prosecutor. Mr. Chairman, don't grant the orders he's seeking. Mr. Chairman, the prosecutor is inviting you to infringe the provisions of the Constitution. Mr. Chairman, you and your tribunal must uphold the provisions of the Constitution. Mr. Chairman, we are not at that level where we may be considered to have moved against the principle of res sub judice. Mr. Chairman, I beg that you disregard all the prayers made by the prosecutor. I beg to rest.
Mr. Chairman, respect to the state here, I made a comment about the discipline and how we are mistreated at the entrance, and he claims that it is because of our conduct, which is not clear. We are told to identify ourselves. We do identify ourselves before we access these premises. This is a public court. As we speak now, you can look at the men here in uniform without name tags, even when the space is provided for. We are here, they have introduced ourselves as you have name tags on your uniforms. Why are they here? Our security here should be paramount as a public place. That should not be an issue of Councillor Five to discuss here. It should be clear and good. With all its powers, the tribunal, through you, Mr. Chairman, you should make that order and directive, and it should be complied with, so that we ensure that we are secure and safe even when we are speaking in this. Thank you.
You are very secure, Council.
You want to make a revision?
Area.
My Lord Chairman, honorable board members, we have a brief rejoinder, especially what was raised by Land Council, Mr. Rukwagu. My Lord Chairman, as far as...
Sit down!
My Lord Chairman...
Sit down! Sit down! Sit down!
Discuss
Much obliged, my Lord Chairman. I was saying that we relying on the decision of Luzira Joseph against the Attorney General. Decision in as far as
you wanted the Kawazuruka. He also has the right to contact
in regard to
much obliged.
in regard to the issue of sub-judice.
And my Lord Chairman, with due respect to my senior colleague, I pray that please respect, because I wouldn't want to exchange with my senior. I have a little respect for him. But be as it may, my Lord Chairman, I was submitting that one, we ran that decision to the Supreme Court, that Luzira Joseph was the Attorney General, it's a 2005 decision, in as far as pronouncing itself on this court. But also, my Lord Chairman, on the decision of Kawasikuruka, my Lord Chairman, we have a ruling which I
please stop taking us on a wayward voyage to self-delusion.
And my Lord Chairman, and my Lord Chairman, if I may read verbatim, as part of the ruling my Lord Chairman,
If you allow me the latitude, our defense team is not fully constituted. So we have no instructions to proceed in respect of the substance of this matter until when our defense team is fully constituted, Mr. Chairman. All we can seek is to have maybe this matter adjourned to another date or any other business, but not concerning this matter. If the prosecutors withdraw their charges against our clients, we have no problem. We shall oblige, Mr. Chairman. I thank you, but we cannot continue discussing or submitting on the substance of this matter. It's premature. I thank you, Mr. Chairman.
They raised discussing court matters in media. Then the council submitted, And I don't know what, if state that's what we are going to make a rejoinder or?
Yes, that's
that one. So that's
Mr. Chairman, before he makes a rejoinder, whatever, we need sort of, excuse me, we need sort of presentation before we go any further.
You have a date posted. A date, yes.
All the way from judge advocate, senior prosecutor, and what the defense is going through. I want to apply to the amicus curiae this matter. Because there are some constitutional issues and human rights issues, and it is on that basis that court can admit us to be amicus curiae. So that we can resolve the unwarranted procedural issues that are engaging us wantonly at this moment. I pray.
Honorable Chairman, we cannot respond to that as we are not interested in any ruling on that. For us, we have no instructions to proceed on anything before we conclude the issue of representation, whereby our lead counsel must be Martha Karua from Kenya.
We then reject the application of having amicus curiae.
Your Honor, my Lord, we cannot proceed without, not even with objections. We need the issue.
And also, we have processes to pursue before the law council, involving the council here and the others, so that we have them expedited and come back on the 17th. We move on to another stage. So we talk of 7 months early Christmas.
No, Council, I think let's give you enough time because it seems whenever you come, now you come to the other extreme. Get enough time, prepare yourselves, and then we'll proceed. I think 7th January is enough. Is that I cannot